case on this morning's docket, State v. Laborde. Counsel, did I get the pronunciation correct for your client's name? Laborde? Very good.
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Jody Laborde, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, I think the issues in this case are fairly narrow. The state repeatedly and unambiguously charged Ms. Laborde with theft by deception. They went to trial on this case, and the facts are found in the Court of Appeals decision in the briefs. Not really highly disputed as far as the facts for our purpose of discussion today. The Court of Appeals agreed in its decision and held that there was insufficient evidence.
I don't know if they agreed. They suggested that perhaps there was an argument there for insufficient evidence. Is there insufficient evidence? Had your client actually asked for the instruction on theft by deception as opposed to unauthorized control? Let's just say that the instruction was given that was consistent with the charging document. Would you be here arguing insufficiency? I mean, was there no evidence in the light most favorable to the prosecution of deception here?
Your Honor, this is the Court of Appeals decision at page 5. I quote, "In the instant case, Laborde correctly asserts that the jury did not have sufficient evidence to convict her of theft by deception." That's my reading of that decision that the court held
why
that.
that's right. There's lots of deception.
Your Honor, the state did not petition for review from that holding. They had the option to cross-petition if they disagreed with that, and it seems by their supplemental brief that they disagreed with that, but they didn't cross-petition. On the merits, the merits of the question, Your Honor, there's no evidence that there was any deception that caused Ms. Laborde, assuming everything in the favor of the state here, we're not conceding anything, but what deception under the state's theory did Ms. Laborde engage in order to exert control over this property? And the answer is none. This is a claim of obtaining or exerting unauthorized control over some property. There is some evidence, maybe, it's really not even very clear, that Ms. Laborde, again, assuming everything in the favor of the state, may have done some deception to dispose of the property, but that's not the question. That's not theft by deception.
Or to maintain possession of it once she'd already had it. There's evidence of that.
That she kept possession of stolen property.
Maintained it.
Yeah. So
does the fact that there were attempts to recover the property and that she used deception to prevent that recovery, is that an exertion of control sufficient for theft?
Again, I hope it's clear. My position is we shouldn't even be talking about this because the Court of Appeals held there was insufficient evidence and the state didn't cross-petition. So I don't even think these questions are before the court. But understanding my need to answer the questions, that's still her maybe converting the property after the fact. There's no evidence of her obtaining control of the property through deceptive means. And that's why I think the Court of Appeals correctly held that there's no evidence of theft by deception in this case. I don't think I've answered your question yet, Justice Rosen, and so I'm trying to come back to...
I think you did when they didn't cross appeal, but in light of the two questions here, why isn't that theft by deception? When you're maintaining possession of the property by lying that you have it.
It's our position that it certainly was the case that theft is the obtaining of it by deceptive property, and that's the distinction. I mean, I think about, it's taking property from somebody. I in some way physically, I go into their house, I go into their yard, I take, as opposed to, the example I use talking about this case is, here's this iPhone, give me $100 for this perfectly good iPhone when it's a fake iPhone, right? I've used some sort of deception in order to get the money, but I didn't take the money from you without authorization. You gave me the money. You intended to give me the money. That's the distinction here. And there's no evidence of conduct like that on behalf of Ms. Laborde in this case, that she got this Army property by some deception. the victim left it. And if you believe everything the state says, as you're required to do for this issue, then she did something with it. But that's not theft by deception. Your Honor, this court has a long line of cases consistent with the United States Supreme Court due process holdings that it's not enough for the state to just prove some crime. They have to prove the crime that they charged. And in this case, even after both parties requested instructions, on November 30th, 2011, the state once again unambiguously filed an amended information charging theft by deception. It is our position that the Court of Appeals was right by finding that there was insufficient evidence of theft by deception, and that regardless of what the instructions say in a case, that cannot affect that analysis.
And that's true even if the defense sought the instruction that it now complains was incorrect.
That's right. And I think...
Do we
the
have a
concept-
case on that point in particular?
No, although I think it's because the Court of Appeals doesn't have any support for the idea that we test sufficiency by the instructions and not the charge. And so I sort of get there. But the idea, Your Honor, it seems to me the invited error doctrine, the purpose of the invited error doctrine, as I understand it, is if I, as a party to litigation, affirmatively ask the court for something, like an instruction, or evidence to be admitted, or omitted, or whatever that situation is, and I cause the district court, by my request, to take some action or omission, then it's against equity for me to come to this court then and say, you should reverse because of that. But Your Honor, the defendant has no power and no influence over what the state charges. That's the state's decision as to what to charge in this case. And the defendant has no power to decide what evidence the state is going to put on in their case of cheat. That's the state's decision. And Your Honor, that's what we think the test is for sufficiency under the Due Process Clause. Did the state present evidence in court of the crime that they charged? Clearly, in this case, they did not. For that reason, we would ask that you reverse this conviction and order Ms. Laborde discharged.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, Richard James, Clay County Attorney, on brief for the state. I would begin by saying I disagree with the appellant that the Court of Appeals did indeed hold there was insufficient evidence. Because when you get to their argument, when you get to the Court of Appeals' statements about invited error, it seems to me that's where the Court of Appeals made the finding. They said, Laborde's claim that the evidence was insufficient to convict her of the crime with which she had been specifically charged may have had some merit, but for the fact she invited any error which occurred by specifically proposing and approving the jury instruction which deleted the element of deception.
Let me just ask a fact question on that point. The defense asked for the instruction. Did the state also ask for that instruction?
We asked for identical instructions. There was only one minor difference in our two instructions. The instruction I asked for said the Army owned the property, and the instruction they asked for said Sergeant Price owned it. So
But
just
the
a
state
very minor.
did not ask for an instruction on obtaining possession by deception.
No, they did not. And like I say, both the defense and I asked for the standard pick instructions, one minor change. So it would appear to me from the way I read the court.
So the defense hoodwinked the prosecution into asking for the wrong elements instruction?
I don't feel like I was hoodwinked, Justice, but as the Court of Appeals has said, do we know? And I don't know. I don't know that the defense didn't go along with me. I doubt it. I'm going to be real honest with the court. I doubt the defense was trying to hoodwink me. I think the defense made a mistake.
Well, let me understand. There's two packets of instructions.
Yes.
They're both. Counsel didn't consult with other counsel about what was to be submitted. You both submitted a packet of instructions that both included the theft under the theory of unauthorized control.
Yes.
As both of you did.
Yes. No, there was no
independent
consultation.
of one another, right?
Pardon me?
Independent of one another.
Yes,
You
there
both
was no
submitted the same-
consultation between
Right.
me and defense counsel on what we were going to submit. In fact, in our judicial district, that would be very uncommon. In 10 years of being county attorney, no defense attorneys ever called me up and said, "Hey, Rick, let's talk about the let's talk about the jury instructions."
Are you still standing by, or do you maintain that this was a theft by deception?
I believe there was sufficient evidence in front of the trier of fact to make that call. And I would, the Court of Appeals said her deception was ex post facto, but her deception began the very night Sergeant Price left the house. He left the house willingly after the domestic dispute. The police came out there and he realized he didn't have his service dress or Class A uniform and was going to need it the next day. So he and the police went back to the house that night and said, "I need my service dress uniform." And she told the police, "He already has it. He took it some time ago." Well, a friend of hers who visited her 2 months later testified at court that 2 months after that, she saw Sergeant Price's service dress uniform in the house with his name tag Price on it. And so the deception began that very night. And as I have argued all along, if two roommates have a fight and one of the roommates leaves the house, but they're both living there, the fact one of the roommates leaves the house, does that mean her roommate has immediately converted all of her roommate's property because she left the house? Sergeant Price thought this was going to be a temporary dispute. He really thought that he'd be back in a night or two back in the house. He left his property at the house where he lived. He didn't entrust it to Miss Laborde that night when the police came after the domestic dispute. And he said, "I'll go to a motel to keep things civil here." He didn't entrust anything to Miss Laborde that night. And in fact, she misled the police that night. Then about a month later, he went back with the police again because in the interim, she had sought and obtained a PFA. So she went back with the police and she told the police again the second time, "I don't have any of his property." However, that night she did turn over a motorcycle that he owned to them. So if the Court of Appeals' opinion is correct and all her misrepresentations are ex post facto, then it would seem to me like she converted the motorcycle the first night too, and perhaps I should have charged her with stealing the motorcycle. But I didn't because the police recovered it a month later when they went back.
These arguments on why there was sufficient evidence to support a theft by deception conviction is hypothetical because the jury did not convict on that charge, did they? They convicted based on an instruction for regular theft,
Right.
exerting
They-
control.
they
And
did
so,
indeed, Justice.
So what you're saying is because they could have convicted of the crime that you charged, then that's okay.
The appellant has always made the point that this is a sufficiency of the evidence argument. There was not sufficient evidence to convict her of the crime with which she had been charged.
Well, so there's no due process issue here?
I believe if this court finds there was sufficient evidence to convict her of the crime with which she was charged, she was on notice that she was charged with that crime. I mean, there was a complaint and information. She was on notice she was charged with that crime. If there was sufficient evidence presented to the fact finder, I don't believe there is a due process issue. If there's not sufficient evidence, I agree with the appellant, there is a due process issue. I believe that there was sufficient evidence, as I've said before, because she made multiple misrepresentations, primarily to the police, because once the PFA was in effect, Mr. Price, or Sergeant Price, was really not allowed to talk to her directly. So his 3 trips to the house over the next 2.5 months all took place in the presence of the police. And it would be my argument that if she'd have said to the police, "Sure, I've got Kevlar vests, Kevlar helmets, I've got all this stuff in my shed," which we found on the 3rd trip, the very first night, the police would have said, "Well, then give it to the guy." And she left. But They left. In fact, Deputy Ken Hughes said right on the stand, we left because we believed her when she said that there was nothing there. We left because we believed her. They relied on her misrepresentation that she didn't have this property. They left, and that allowed her then to convert some of it. About half of his gear was never recovered. They found about half of it there in the third visit, but about half of it was never recovered. They relied on her misstatement that she didn't have any of his gear. They left, and as a result, over the next couple of months, about half of his military issued gear, about $4,000 worth, disappeared. And had it not been for her representation, the police would have been much more aggressive. As this court's well aware, in domestic violence situation, it's not unusual for the police to have to help whoever leaves the house to recover their property.
So is it your position that we really don't even get to invited error, that there's sufficient evidence to support the charged crime and therefore the instruction either way, there's no error? What's your position?
I believe there was obviously error when the jury instructions don't match the complaint or the information. But I don't believe we get to invited error, because I believe if whatever error there is, if she's convicted of the crime that she was charged with, and there was sufficient evidence presented to that trier of fact to convict her of the crime with which she was charged, and she was on notice, she was charged with that crime, then I believe whatever error may have occurred because a jury's instruction was incorrect is harmless. I believe we've met the constitutional demands of a defendant being put on notice. Oh, I'm sorry, Justice.
No, go ahead, finish your thought.
I believe we've met the constitutional demands that a defendant has a right to know what they're charged with. They have a right to a trial, and in that trial, they have a right to make the state produce sufficient evidence to convict them. And I believe all of those things happened.
Don't they? Go ahead.
Go ahead.
I interrupt
Go
you?
ahead.
Doesn't the defendant also have a due process right to have guilt determined by a jury beyond a reasonable doubt? And that's the key due process element that's missing here. In other words, it doesn't matter, arguably, whether or not sufficient evidence was presented if the defendant did not receive his or her due process right to have guilt determined by a jury beyond a reasonable doubt on the crime charged.
Right. And obviously, she was found guilty, I guess, in the minds of these jurors, beyond a reasonable doubt
Of a different crime, right?
on a jury instruction that instructed with the elements of a different crime. You're exactly right.
So the jury did not convict this defendant of the crime of theft by deception.
They convicted her. You know, juries don't understand those concepts, as you well know.
Well, but that's
Juries
just a fact,
understand the
isn't it,
elements.
in this
They look
case?
at the elements.
Right.
They look at the testimony.
And that's
and
why
they
the
say,
instructions matter, counsel.
Pardon me?
That's why the instructions
Yes,
matter.
they do matter.
And the way you described it, the jury could have well found that she exercised unauthorized control when she took the property and put it in a shed, where the true owner did not know it was being held. So that was her, but they may have not found that she obtained that control through deception. And so that's what we're saying is they're not the same. They're two different crimes.
And I understand.
And there were different facts by which the jury had to find for each crime.
Sure.
So that's why we're saying the missing piece here is a
Right.
jury conviction on the charged crime.
Right. However, I would argue there was sufficient evidence to allow a reasonable fact finder to find her guilty of either crime. I think.
So let's move on to the Court of Appeals affirming, kind of jumping over all that and saying it was invited error. What if, and I understand the argument, or the holding, but what if Laborde's counsel would have proposed an instruction for robbery, and the jury found him guilty of robbery? Would we still say that's an invited error?
Well, the court dealt with that in State v. Robinson, which was cited by the appellant. But the Court of Appeals distinguished Robinson, and they said the difference was because in Robinson it was a robbery, and in Robinson they received a jury instruction that involved taking from the person when all the evidence said provided at the trial was taking from the presence. And the court said that's different. Robinson is different because in Robinson, the evidence at trial, the jury could not have found the defendant guilty of the evidence of the crime as charged based on the evidence at trial. That's what the Court of Appeals said. And so that would be similar. If the defendant had submitted a robbery instruction and all we had presented was the theft evidence, then I think the Court of Appeals would agree with your argument that this doesn't work, because then we're at Robinson. But the Court of Appeals distinguished Robinson and said, no, what makes Laborde different, according to the Court of Appeals, is Laborde, there was sufficient evidence to convict her of the crime based on the jury instruction that the defendant asked for.
Right, that there was evidence of unauthorized control.
Right.
And that's what he asked to be instructed on.
And I know this...
Is there anything in the record that indicates why that instruction was wanted by both parties, or especially by Laborde? Was this strategy? Was this... Do you understand why that was asked for?
I do. I believe... there's nothing in the record. I believe it was a simple mistake on the part of the defendant. However, as the Court of Appeals said, they can't eliminate that it's part of a defense strategy. And as I stand here before you, can I say it was not part of a defense strategy? No, I very much doubt it.
Whose responsibility is it to instruct the jury?
The judges. I don't believe that the defense was trying to somehow fool me. But I cannot say that with 100%
Well, it doesn't matter if
certainty.
he was fooling you. If it's a judge's responsibility, it's vis-a-vis the court.
I understand, Justice. I understand. I believe my time is about it.
Any more questions? Thank you, counsel.
Thank you.
Your Honor, I don't have anything further other than to reiterate our position that the Court of Appeals held there was insufficient evidence. Otherwise, I don't even know why we are talking about invited error. And the state did not cross-petition for review, so we would ask you to hold to your rules on that.
Normally, we look at the issue related to not instructing on the charged crime as it somehow doesn't give your client notice, opportunity to prepare, there's some sort of prejudice as a result of that. Here you request the instruction, and there's plenty of evidence to support the unauthorized control theory that is offered in the instruction. What's the prejudice?
Actually, Your Honor, I respectfully disagree with your premise. I think a lot of times when you talk about this, you talk about it from a subject matter jurisdiction point of view. And that, in fact, in Dixon and Bobby Johnson, in those cases, you've said, look, if you charge somebody with one crime and you convict them and there's evidence of some other crime, there's no subject matter jurisdiction to do that. And you haven't, in fact, required prejudice in cases like Andrew Dixon and Bobby Johnson and Chapman in those cases. And there might be, I think there probably is a subject matter jurisdiction consequence to some of this variant as well. That's not the way we raised it in this case. Because we raised it in terms of sufficiency, which we won on in the Court of Appeals as far as the sufficiency issue.
Any more questions? Thank you,
Thank
counsel.
you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.